Well, my learned brothers and sisters, this is Advocate P. Devmorari talking to you from Ahmedabad city, Gujarat, India, that is Bharat. Today I have selected a very current topic affecting our entire society, that is criminal breach of trust and cheating. And the last part is very important. Criminal breach of trust and cheating do not coexist. You cannot charge both the things from one set of fact. Now, to understand deeply this legal point, let us understand certain IPC and BNS sections. Indian Penal Code 403, 405, 406, 409, 30, that is valuable security, 420, cheating. Contract Act section 73. And now the present law, Bharatiya Nyaya Sanhita 2023, in short, it is known as BNS. Section 316, subsection 1, 316 in bracket 2, 316 in bracket 5, 314, 2 in bracket 31. And Bharatiya Nagarik Suraksha Sanhita, section 518, because it is not a continuing offense, means criminal breach of trust and cheating are not a continuing offense. It is in CRP section is 472. Now the first important question is, who can make complaint? Complaint must be made by the injured or by agreed person, and it must be such a grievance as the law can appreciate it. It means it must be a legal grievance. What is the condition precedent? What is the important point to be observed in mind? Before the offense of cheating can be made out, it has to be shown that damage or harm has been caused to a person so deceived, where the deception is to A and loss is caused to B. No offense of cheating is made out. The basic requirement to bring home the accusations under section 405 of IPCR, the requirements to prove conjointly. Now I'll discuss about ingredients. Conjointly it is to be proved. IPC 405 equivalent to present law, BNS section 316 in bracket 1. First ingredient, entrusting any person with property or with dominion over property. Second, that person entrusted. Now, refer IP section 405 illustration C. Entrustment, what does it mean? In any manner, these are the words. Now let us see the interpretation. Entrustment arises whenever something, whether money or anything, is given to some person with some direction as to how it should be dealt with. In other words, if the person paying intends to repose trust in the other, expecting him to dispose of the money in a particular way, then only there is entrustment. It means direction is given. That the person entrusted dishonestly misappropriates or converts to his own use that property, or dishonestly uses or disposes of that property, or willfully suffers any other person so to do in violation of any direction of law prescribing the mode in which such trust is to be discharged, or of any legal contract made touching the discharge of such trust. Now it is clear that the most essential ingredient of proof of criminal breach of trust is misappropriation with dishonest intention. Only misappropriation is not offense, but it must be with dishonest intention. The act of criminal breach of trust per se may involve a civil wrong, but a breach of trust with an ingredient of mens rea would give rise to a criminal prosecution. Now let us move to IP section 409, BNS section 316 in bracket 5. Whoever being in any manner entrusted with property or with any dominion over property in his capacity of a public servant or in the way of his business as a banker, merchant, factor, broker, attorney, or agent commits criminal breach of trust in respect of that property shall be punished with imprisonment of life or with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. We have seen earlier ingredients of criminal breach of trust were discussing in IPC section 405. So I don't repeat it now. Now let's move to cheating, IPC section 420, BNS section 318 in bracket 4. The complaint, in order to prove the offense of cheating, is required to show that the accused had fraudulent or dishonest intention at the time of making promise or representation. Even in a case where allegations are made in regard to culpable intention at the time of making initial promise being absent, no offense under section 420 IPC can be said to have been made out. Now, while framing the charge of IPC section 420, if magistrate makes a mistake, what mistake? Omission, when it is material. Magistrate's failure to set out particular consequence by virtue of which the deception becomes offense. Omission is the charge considered material. So, what is the result? Acquittal or discharge or caution. Now, let us discuss IPC section 30, that is valuable security, BNS section 2. Please remember, mere failure to fulfill a promise to pay does not indicate dishonest intention unless deception was present at the outset of transaction. Such a culpable intention right at the beginning, when the promise was made, cannot be presumed, but has to be made out with cause and facts. Cause and facts are to be stated in the complaint or in the suit. The Contract Act section 73 deals with compensation for loss or damage caused by breach of contract. It can help to decide distinction between civil and criminal liability. In the case of mere retention without any misappropriation, there is only civil liability. Unless there is misappropriation, there can be no question of dishonest misappropriation. Now, the last legal point, which is most important to remember for everybody, that is, criminal breach of trust and cheating cannot coexist. I've come across a number of charges. Police is charging both the sections, IPC section 420 and 406, but it cannot coexist simultaneously. If it is the case of the complainant, the offense of criminal breach of trust as defined under section 405 IPC, punishable under section 406 IPC, is committed by the accused, then in the same breath, it cannot be said that the accused has also committed the offense of cheating as defined in section 415, punishable under section 420 IPC. There is distinction between criminal breach of trust and cheating. For cheating, criminal intention is necessary at the time of making false or misleading representation since inception. In criminal breach of trust, mere proof of entrustment is sufficient. This is the basic difference. There is a criminal breach of trust. The offender is lawfully entrusted with the property and he dishonestly misappropriates the same. So it becomes an offense. Whereas in case of cheating, the offender fraudulently or dishonestly induces a person by deceiving him to deliver property. In such a situation, both offenses cannot coexist simultaneously. Consequently, what is the effect? Ultimate effect. The complaint cannot coexist simultaneously in the same set of facts. Why? Because they are antithetical to each other. Hope you have enjoyed this video. Thank you very much for patient hearing. If you like this video, please subscribe it, like it, and share it. See you in the next video. Thank you very much from the bottom of my heart. Okay, say.